Welcome to the Bali International Arbitration and Mediation Center webinar on energy and mining disputes, unpacked from project pressure to legal battles. My name is Madeline Kimei. I have the honor to moderate this session this morning. To those joining us elsewhere in the world, good afternoon and good evening. Now, energy and mining activities have always sat at the heart of international transactions, and in more volatile world, disputes are arising more often. If we look at the ICSID, the International Center for Settlement of Investment Disputes, this particular organization, which administers international investment or investor-state disputes, in its new report for new cases filed in 2025, we can see that disputes by sector, and this particular sector, E&R sector, energy and natural resources, is growing, having taken 20.5% of the cases that came in 2024. And then at the London Court of International Arbitration, we can see this particular sector also taking up 10% of the caseload that came in 2024. And in 2025, we can see the rise at the ICSID being 43%, and for the electric power and other energy, 12%. Now, the 20.5%, apologies, that was the ICC, International Court of Arbitration figure for 2024. Apologies for that. Now, what happens in international contract disputes? What does international arbitration for an energy or mining dispute look like? You may be asking yourself. How do companies both mitigate the risk up front, and what kind of strategies are put in place for handling disputes and arbitrations once they come up? Our speakers today will dive into all these questions here during our session and talk about disputes, arbitration, potential pressures that arise in energy and mining sectors, particularly from an international perspective. I'm looking forward to this session as much as you are. The session will run for about an hour and a half. We'll have a 30-minute presentation by each speaker and have a 30-minute question and answer session. Please submit those questions in the chat box below. Now, if time permits, we will open up the floor to those who wish to raise their hand and participate verbally via this particular platform. Now, to get us started, let me start by introducing our distinguished panel. We have Mr. Dendi Adisuryo. He is a partner at ADCO Law in Jakarta, Indonesia. Dendi is a corporate lawyer and a dispute strategist specializing in high-stake energy mining infrastructure and smelter projects across Southeast Asia, particularly those involving public-private partnerships, PPP, cross-border investments, and state-influenced sectors. He has worked with sponsors, investors, and multinationals to navigate legal and regulatory complexity in projects ranging from multi-million to billion-dollar scale, where legal precision, political sensitivity, and commercial interests intersect. He plays a dual role, both front-end structuring and back-end dispute strategy. Dendi also works in structuring joint ventures, optimize regulatory positioning, and advise on capital deployment in politically exposed or heavily regulated sectors. And on the other hand, he also acts as a lead strategist in high-value disputes, from permit cancellation, smelter project breakdowns, and mining joint venture collapses, to complex regulatory challenges, and state asset controversies. Mr. Adisuryo has represented clients in critical disputes involving government-linked counterparties, coordinated multi-stake legal defenses, and crafted litigation arbitration hybrids that protect value and preserve future cooperation. In the transaction space, Dendi has advised on coal and nickel mining ventures, smelter developments, power purchase agreements, project finance, restructurings, and strategic exits. His role often involves working behind the scenes to align legal strategy with the commercial, regulatory, and political realities that shape large-scale energy and extractive projects across Indonesia. On behalf of BIAMC, we are very happy to have you with us, Mr. Dendi. Now, we will kick off our session with our first presentation from Mr. Dendi. He will be speaking on mining disputes in Indonesia. Mr. Dendi, the floor is yours.
Thank you. Thanks, Madeline, for the wonderful opening and introductions. Good morning, good afternoon, good evening, wherever you are joining from. And thank you for making the time. My name is Dendi Adisuryo. I'm a senior partner of ADCO Law in Jakarta, where I lead our mining, energy, and dispute resolution practice. So, yeah, this session is a part of the BIAMC, that's how I pronounce, webinar series on Indonesian Arbitration Center. And today, the topic that I'll be speaking on is about the mining dispute in Indonesia. So this is the title of our discussions: Mining Dispute in Indonesia, Classifications, Forum Selections, and Dispute Resolution Strategy. So before I start, two practical points. First, I will keep slides on the screen throughout. So the slides are designed to be self-contained, so feel free to focus on whichever element is more useful to you. And the second, please hold your questions until the end as directed by the moderator. I think we have a fair amount of time to cover and discuss all the questions. Yeah. Next. Okay, here's how I propose to spend our time in the next 30 minutes. I will move to 6 sections. The first is regulatory development. I will start with what has actually changed in 2025, mid of 2025 and early 2026. And what we believe is because that is the driving the dispute we are now seeing, or we anticipate to see in the next couple of years. And the second is the classifications of mining dispute, 6 recurring categories under Indonesian practice. And 3, we'll discuss about hypothetical dispute scenarios. Yeah. This is the longest sections that we'll discuss through our discussions time this afternoon. I will walk through 4 illustrative facts patterns: coal supply, EPC, regulated pricing, project financing. And for each one, we'll try to discuss on the evidence and expert evidence you would actually need if any of you face this typical dispute in the mining industry. And next is the forum selections. Court is very traditional and classic comparisons, court versus arbitrations, and side-by-side comparison between BANI, SIC, and BIAMC. 5 is mitigation and litigation, and 6 concluding observations. Let's begin with section 1. Next slide. Regulatory developments between 2025-2026. This is a measure of the government of Indonesia affecting mining contractual risk. Next slide. Why begin with the regulations? Yeah, this is a very important questions, because between 2025, mid 2025 and early 2026, the government of Indonesia introduced a number of measures and initiatives that materially affect the mining operations in Indonesia. And more importantly, that changed the contractual risk allocations. We will discuss later on what the actual typical risk allocations that change due to the dynamics in the regulatory point of view. So that changed the contractual risk allocation in ways the original drafting of long-term mining contracts often does not address. So most of the contracts we are now litigating or arbitrating were drafted maybe 2 years ago, 5, 10, sometimes 15 years ago, and they were drafted against a different regulatory baseline. And the dispute we are seeing arise precisely from the gap between the drafting and today's reality. So these are the three preliminary questions. Yeah, the first is identification exposure, which category of regulatory measures give rise to which form of contractual claim. Second is pathway of claim, and the third is the pre-dispute conduct. What measures should be taken in respect of clause review, evidence preservation, this is a very important thing, and forum selections prior to issuing notice. Next slide, please. These are the 5 developments that we have in Indonesia during 2025 and 2026. For those who are actively involved in the mining industry, the first and the third point are very critical. Yeah. So the first is the RKAB quota reduction. RKAB is the annual work plan and budget. So basically, it's a production quota. Every year, all the miners will be given an annual quota, 5 million ton, 10 million ton, and so on and so forth. And the Ministry of Energy and Mineral Resources, yeah, ASDM, in this 2026, reduce drastically the production quotas. Yeah, just for example, the production quota for nickel is down approximately 30%, and it's not 30% for all. A company can get 60% compared to the production quota last year. Other company will get 50%. Other company will get 40%, and so on and so forth. So the 30% is for the general. Coal is down approximately 24%. Again, this is the average. There are a couple of miners, especially in the early version of the contracts, yeah, in Indonesia, CCOW, maybe they will get 100% quota compared to last year production quota. But other companies, they got 70%, they got 50%, and there are a couple of companies only get 20 to 30% quota. And as per company allocation, may be reduced further. And again, for long-term offtake contract, this is a single most consequential measure because the effect will be very significant. The second is the royalty and benchmark marking. Yeah, so there is a new regulations, government regulations, peraturan pemerintah 18/2025. The regulation basically increase the royalty rates. Yeah, and there is also the price reference for export, and there is a change in how the calculations of the royalty. In mining industry, there are 2 types of the government contributions. The first is the royalty. The royalty means a certain percent times the price of your commodity. And the second is the dead rent. Dead rent is the fixed payment payable to the government based on certain tariff times whatever the hectares you have under your concessions. And the royalty and benchmark pricings was changed based on recently issued government regulations back in 2025. The third point, this is a very interesting, if for the Indonesian participants and who are involved in mining industry, this is very important because now Indonesia has a forestry enforcement task force, or we call it Satgas PKH. The Satgas, the task force, was established based on the government direction. the president direction. So the president himself, President Prabowo himself, directed the establishment of this forestry enforcement task force. And the authority, the scope of the authority is very wide, from stopping the activity, from giving a very significant penalty, stopping the activity, and forcing the how to say, it's not a big expropriation per se, but forcing a company to return a certain part of the concessions area back to the government. We'll discuss later what are these things. And the one is the hilirisasi or downstreaming. So downstreaming is not something new in Indonesia. It was introduced back then on 29 based on the new mining law. But now the circumstances a bit different. Captive smelter and processing capacity commitments entered prior to 2026 must now be performed again, reduced upstream of quota. So the ore quota is reduced. That's why if we see there are several, it's not all, but there are several smelters stop the productions because the shortage of the ore supply, the PG, yeah, the ore quota supply. And the result is a structural feedstock supply mismatch. So the smelter capacity this much, but the supply of ore, the raw material is this level. So the mismatch is quite significant. That push several smelters stop operating early this year. And the last one is the ESG and supply chains conditionality. This is not something initiated by the new administrations, but it was initiated during the last administrations in Indonesia, that approximately 31 gigawatt coal-fired power plant will be terminated, will be replaced by the greener power plant. So this will create some sort of complexity in the terminations of the active and ongoing power plant project. So these are the 5 developments in the last 12 months that, based on our observations, will bring significantly number of dispute or potential dispute in mining industry going forward. Next slide. So these are the number. I will not read every figure on this slide. So this is only the number illustrating on the change of the government policy. The first is the nickel quota. So last year, the nickel quota is 379 metric ton per year, but now it is cut to 255 metric tons. So it's about 30%. Same things also in coal quota, almost 100 million ton last year, but now nearly only 600 million ton. So the nickel quota cut by approximately 30%, and coal quota 25%. But again, this is not apply for all. There is a company who is not affected by the cut, but also there are a couple of companies, the cut of the quota up to 70%. And this is also the change of the coal royalty, 40% on regulated price tons, and then 60 days royalty settlement, and then also the penalty tariff by the Satgas Forestry, by the Forest Enforcement Task Force, So the penalty is 5-6 billion rupiah per hectare per year. 5.6 billions, approximately 400,000 US dollar per hectares per year. So if the company is accused to illegally use forestry area for 100 hectares for 10 years, so the government just multiply 400,000 times 100 hectares times 10 years. So the numbers is very significant. And for the mining companies, until January 2026, the total fine is 1.8 trillion. So it's about 1 billion US dollar in total. The fine collected from mining companies, mostly in nickel, but now it is moved to coal as well. Next slide. Okay, this is the classifications of mining dispute. Next. Yeah. Why does classifications matter? Because each category has its own forum logic. Not all this dispute can be settled in arbitrations. Yeah. So, for example, the concessions. Yeah. Overlapping. For example, this is just a sample of the dispute in the concessions. Yeah. Overlapping areas, conversion of COW. COW is the coal contract of work. This is the contract between the government and the business entity for mineral. Yeah, and CCOW. CCOW is the coal contract of work. This is the contract for coal. Yeah, so the conversion from COW into IUP. Spatial planning conflict, forestry permit issue, revocations of mining business license. Recently, the Minister of Mining, openly in public, will start reviewing hundreds of mining license in Indonesia based on the direction and instructions from the president, and will start revoking mining license which categorized as non-compliant. Yeah. The second is the dispute in investment, share transfer dispute, post acquisitions, warranty and indemnity claims. Yeah, mining business development agreements, nominee arrangements. Yeah. Three is operationals, common mining service agreement. So most of Indonesian mining companies, they are not doing the mining activity by themselves. They appoint a party to provide mining service agreement, vendor agreements, fuel, equipment, material, supporting materials, yeah, land clearing and fuel supply. Fuel supply, here's the challenge in Indonesia, but I believe it's not only Indonesia. It's about the increase of the energy price in Indonesia. If not mistaken, the price of the industrial diesel is 30,000 per liter, 30,000 rupiah, compared to the price before the conflict in Iran. The price at that time was just 6,000. So it is almost double. Definitely, it will create the stress. It will create the challenges between the concession holder and also the operator, the mining service provider. The fourth is the commercial, the commodity, sell and purchase, delivery, force majeure. It was committed to supply 5 million ton per annum. Then immediately the government said, no, you cannot make 5 million per annum. You just your quota is just for a million. So whether we can declare it as force majeure or not, yeah. Specifications, pricing, and additional costs. Five is financing, yeah, government bridge, cash account management agreement, cash water fund, and so on. And the last thing is land and forestry, land acquisitions, because in Indonesia, having a mining concession doesn't mean you own the land. So based on the law and regulations, when you have your mining concessions, before committing in a mining activity, you have to compensate either buy, lease, or any other cooperations with the landowner. So you cannot just start the operations without compensating the landowner. So that's also source of the dispute, and also the forestry issue. The PPK. PPK is the borrow to use forest use permit, and Satgas PKH repositions. Like I said before, there is a task force of Forest Enforcement Authority who has a very powerful authority. Next slide. So hypothetical. Okay, next slide. Okay, this is the summary of the 5 dynamics, 5 changes in Indonesian's regulatory and policy point of view, and the effect to offtake, EPC, loan, insurance, GV, and so on and so forth, and the degree or level of risk of dispute caused by these 5 dynamics. Next slide. Okay, I just want to share about hypothetical case, affected by the RKAB. RKAB is the annual productions reductions. So this is the hypothetical fact patterns. It's happening now. It will be happening in the near future. Indonesian producer is a party to a 10-year coal supply agreement with a foreign utility company for delivery of 4 million ton per annum of the thermal coal. For 2026, RKAB, the producers approved quota, the production quota, annual production quota, reduced by approximately 55%. So last year they can make 4 metric ton per year, but today they can make only 2.1 until 2.2 metric tons per year. The producer issue a notice of force majeure relying on an act of government. The buyer dispute the validity of the notice, procure replacement cargo at a higher cost, and asking for the gap value between the replacing cargo and the original cargo, and commence arbitration claiming the price differential. And in Indonesia, there is no frustrations concepts, unlike as the common law system. So we have only force majeure, and whether this typical event can be deemed as force majeure or not. That's a legal issue. So the legal issue whether a quota reduction falls within the force majeure clause, because there is no hardship, there is no frustrations under Indonesian's law. Whether the producer is entitled to allocate the supply pro rata, or whether the measure was foreseeable, because it is not the first time Indonesian government cut the quota. It has happened before that the government cut the quota 10%, 20%, 15%, but it is the first time that they cut until more than 25%. Quantification of damage, evidence of producers' own conduct in the RKAB process. So this is the position of the producer and position of the buyers. Next slide. Okay, this is the once a party enter kind of dispute. So these things should be taken immediately. Documentary evidence, RKAB. So RKAB submission file, annual technical financial report. So RKAB must be submitted on November every year. So whether we submit it, whether the company submitted on time, whether all the required documents submitted in complete form along with the RKAB submissions, regulated determination performance of and notice record. So this documentary evidence, a party should immediately compile and collect. Witness of facts. If you represent, or if you are part of the coal supplier, for example, you start listing the witness facts. Who are the witness who hear, who listen, or who do by himself the activity. Yeah, and also expert evidence or expert statement, mining engineer, coal market, quantum expert, Indonesian regulatory expert. So once potential dispute is triggered, so these two things that you have to start preparing. Just to save time, I will skip scenario A and B and C. Maybe we can move to the next slide. Again, next slide. Okay, this is the Satgas PKH repositions. This is the hypothetical pattern. So Satgas PKH block the activity. These are the legal issues. Next slide. Okay, this is these are the things that we have to prepare and start collecting if a party is affected by the Forestry Enforcement Task Force activity. Next slide. Next slide, again. Next. Okay, project finance, senior secured facility to mining company. Because the borrower LKAB is reduced, then the ability and capability to repay the loan is disrupted, and it will create a positions where the lender have the capacity or have the basis to issue dispute notice. So this is also the very anticipated dispute in Indonesia due to the change in the government dynamics. Next slide. Next. Okay, forum selection and procedure. Next. Okay, this is very general matter for consideration before a notice. Characterization of triggering events, preservations of evidence, drafting of notice, and compliance with multi-tier dispute resolutions. For point number 4, you have to follow the procedures and set of a mechanism before you can submit your arbitrations notice. There is an agreement who adopt the pre-dispute board. So just for example, before you enter into arbitrations, you have to appoint independent panel expert, for example, to examine and to adjudicate your case, or you have to spend 30 or 60 days amicable discussions before you can serve arbitration. So you have to carefully review your dispute resolution process before you move forward into arbitrations proceeding. Next slide. This is the comparative summary between court in Indonesia compared to arbitrations, Bali, SIC, or BIAMC. The cost in court filing and administrative fee are very modest, very low. I think it's just 2 or 3 million rupiah, worth about $200. In arbitration, institutional fee and arbitration fee are substantial relatively compared to the cost of court. The recourse in court in Indonesia, there are 3 tiers. Yeah, 3 tiers. The first is the first level, is subject to the appeal to the High Court, and the High Court award subject to appeal to the Supreme Court, and subject appeal to the judicial review. And in arbitration, this is the final. There is no appeal against the decision from arbitrations. The execution, the court may give effect to its own decision directly, but in arbitrations, an award must be registered with the district court before execution. Yeah. Composition judges are appointed by rotation, so technical familiarity with the mining is not something assured. But in arbitrations, you can appoint an arbitrator with a specific expertise in the relevant field. So you can have someone with the knowledge, with understanding, with the experience and technical experience in your particular disputed matters to adjudicate the case. So you are not appointing a layman, quote unquote. to adjudicate your case. Confidentiality in court is not confidential because proceedings are open to the public, but in arbitrations, it's conducted on a confidential basis. Next slide. This is the comparative procedural and cost framework between BIAMC, Bali rules, and also SIC. I think you can take a look and review this and compare which more fit with your circumstances. Next slide. Now, this is the general principle procedure stages for the arbitration proceeding. The first is statement of claim, request and defense, and nominates an arbitrator. The respondent submit a statement of defense and nominates also an arbitrators. The second is the tribunal and preliminary. The arbitral tribunal is constituted. The tribunal issues procedural order and the timetable and the schedule, and they consider the principal issues to be addressed. Third is the written submission. 4 is the hearing. 5 is the award and submissions. In arbitration, interim measures, the interlocutory decision is not separate procedural states. They may be sought at any time during the proceeding, but in the practical point of view, you have to see the practicability and the enforceability of the interim measures. Next slide. So this is the interim measures, theoretical availability and practical limitations. So in Indonesia, tribunals, the arbiters may order an interim measures. Yeah, this is stated in the Article 32, empowers a tribunal to order conservatory seizure, sita jaminan, deposit of good with a third party, and sale of perishable goods. Yeah, but there is a practical limitations. Yeah, enforcement is uncertain because in Undang-Undang 3099, the arbitration law contains no provision for the enforcement of the interim awards. So if you have the interim awards from the arbitrations, then you have to bring it to the court to have the executions ordered just for the interim measures. So that's the challenge under Indonesian's law. Okay, next slide. So this is the mitigations and litigation measures, pre-dispute preparations, and conduct of proceeding. Mitigation measures prior to dispute. So we have to do due diligence against our counterparty, ascertain the insolvency, the beneficial owner, regulatory standing, litigation history of the country before contracting. Yeah. The drafting of the agreement, the arbitration agreement should be negotiated in a substantive term, forum, seat, applicable rules, language, or any multi-tiered procedures. Yeah, multidisciplinary advice, technical, financial, legal, yeah, regulatory compliance, maintenance of recourse. That's prior to a dispute. But when the dispute happens, this is the measures upon the dispute. The first, the identification objective. What are the objective or the principle? Recovery of damage, declaratory relief, injunctive relief, or what is the actual objective of the proceeding? It is a very important. Sometimes the client even they don't know why they want to fight in arbitrations. We as a counsel, we have to identify, we have to agree with the clients what is your actual objective, whether you want to recover your damage or you just want to have a winning paper, but no meaning on the reality. So we have to identify the objective very carefully. Evidence and witness, like we discussed before, we have to start collecting the evidence and witness, cost and benefit enforcement in Indonesia, and I believe in many other countries. Winning decisions in our favor from the arbitration institution is not automatically get enforced. So we have to do a subsequent activity, subsequent procedures to get it enforced. And selections of counsel. You have to be careful in selecting your counsel. If you are disputing a construction dispute, then you have to appoint a counsel who understand the constructions. If you want to dispute, if you are in dispute in the financing, then you have to appoint a counsel who understand the lending and borrowing transactions. The selections of counsel and arbitrators with relevant subject matters is to be commended. Next slide. Okay, this is as concluding observations, the cumulative character of the regulatory measures. Yeah. And the second is the arbitration agreement is a substantive term. The first notice is substantive documents, and then enforcement should be addressed at the outside. Next. As a closing remark, the mining sector in Indonesia is undergoing material regulatory changes. The dispute that arise in this period will be determined less by elegance of the contractual drafting than by a discipline with which the parties have prepared. The point addressed in this presentation are intended to assist parties and counsel in that exercise of preparations. I think that's the presentations. Back to you, Madeline. Thank you.
Thank you very much, Dendi, for that insightful presentation of the mining disputes landscape in Indonesia, the entire legal framework, and the risks that are usually seen on a practical perspective. Thank you.